In this penultimate lesson examining the actus reus of an offence, we're going to start to talk about the concept of causation. We're going to talk about causation in two lessons specifically. We'll talk about it here generally, talking more about causation in fact, and then we will talk about the concept of legal causation or causation in law in the next lesson, as well as the concept of intervening causes within a particular act, which could potentially negate criminal liability. So ultimately, this means essentially that we're asking the question of, do the acts which are considered to be unlawful causally lead to the harm which resulted? And that question is one which is important for those who are trying to establish the actus reus of an offence. But it's only important for certain crimes. Specifically, it's only important for result crimes. Causation is a principle, of criminal law which will only apply to a result crime. It will only apply to those kinds of crimes. A result crime is simply one which requires a particular end result to occur as a result of the criminal conduct. This makes perfect sense. So, for example, murder is a result crime since it requires the death of the victim. If the person doesn't die, then it can't be murder. As simple as that, unfortunately. And at the end of the day, there may exist other kinds of crimes that exist. So, for example, conduct crimes. A conduct crime is one whereby an individual exhibiting a particular criminal behavior may be guilty of an offence regardless of whether or not that particular crime results in some kind of end state. So driving a vehicle whilst dangerous, whilst without insurance, or driving a vehicle dangerously. These are both conduct crimes. These are crimes that you don't need to have there have been a result that causes criminal liability. Driving a vehicle dangerously doesn't necessarily have to result in an accident or someone getting run over or some kind of damage. It could just be driving dangerously, at which point you have already satisfied the liability within criminal law. Similarly with driving without insurance. You may drive from point A to point B without insurance and it be a completely innocuous and perfectly reasonable vehicle journey where nothing bad happens, but you would still be committing an offence in the sense that the mere act of driving without insurance is where the criminal liability arises. So, causation only applies to result crimes, and of course the reason why this is the case is because there has to be a harm caused by the unlawful conduct, and this harm has to have been caused by the defendant who is charged with the offence. So let's think about causation in a bit more detail, and we're going to begin with something known as the but-for test. This is the first question that we ask when we talk about how to determine causation, and we're going to get into this in more detail as well when we look at causation relating to the law of tort, because a number of the similar principles exist across both tort and criminal law in this regard. So the question is, how do we determine causation? Well, we first have to make a delineation between causation in fact and then also causation in law. These are things that we're going to look at firstly in fact in this lesson and then in law in the next. But essentially, causation in fact is a factual matter. Did the defendant cause the event to take place? Causation in law takes account of the fact that while the defendant's conduct may be a cause, is it enough to meet and merit the liability for the legal cause? And so essentially what we have to do is take into account what are known as intervening causes, new intervening causes, because for the most part, unfortunately, the world is a lot more complicated than we would like it to be, and a lot of acts that are caused may be caused by multiple different factors. There may be multiple different causes for one single event. And so to really determine whether or not there is accountability in that regard, we have to think about these new intervening causes and the extent to which they contributed to the event taking place. So there may be instances where there are other factors which intervene, and as a result there is more than one cause, and so as a result there is the question of where liability actually sits in relation to certain events which take place. But causation in fact is determined by the but-for test. So the but-for test essentially asks us to examine this question. Essentially, but for the conduct of the defendant, would the result have happened? The result which gives rise to criminal liability. So essentially, if it wasn't for the conduct of the defendant, but for the conduct of the defendant, would the result have happened? If the answer is no, then we can say that the defendant caused the result. Because if we say, well, if it wasn't for this conduct, would the result have happened? And the answer is no, then that tells us that the conduct of the defendant causes the action, and therefore we would say that D caused the result. If the answer is yes, if the defendant can be taken out of the situation completely, and the same result would have still happened, okay, the result that gives rise to criminal liability, then this means that the defendant did not cause the result, okay? And the very famous case that we can look to is from 1910, the case of R. and White. And this tells us and shows us how causation is applied in law. It's an incredibly interesting set of facts. Ultimately, in this case, the defendant wanted to murder his mother, okay? And he attempted to do so by putting cyanide in her drink. His mother then had drank some of the drink, but then died from a completely unrelated instance of heart failure. You can't make it up. And ultimately, the medical evidence in the trial showed that the cyanide wasn't the cause of death of the defendant's mother. In fact, the victim died of a completely unrelated incident, and just by pure luck was this at the same time that the defendant had put the cyanide in her drink. And so as a result of which, the defendant wasn't the cause of the death of the mother. So while he was convicted of attempted murder, which doesn't require the death of the victim, it just requires the intent and an action which goes a long way to the murder itself. He could not have been convicted of the murder fully, because if we were to apply a strict application of the but-for test, we would say, well, but for the actions of the defendant, would the victim still have died? And the answer to that question is yes, because if the defendant hadn't have put the cyanide in her drink, then the mother would have still died from this completely unrelated instance of heart failure. And so as a result of which, you cannot argue that the defendant was the cause of the death, even if he wanted to be the cause of the death or intended to murder his mother. A similar instance comes from 2018, a little bit more complicated, this case, the case of Wallace. Ultimately, the facts of this case determine really where the Court of Appeal stood on this issue. In this case, the defendant was the ex-girlfriend of the victim. They had broken up, and following the breakup and the ex-boyfriend forming a different relationship, the defendant then decided to attack the victim with acid. Okay, I believe famously saying, "If I can't have you, no one can," something like that, and then throwing this very strong acid onto the defendant. The medical testimony of the effect of this acid isn't a particularly fun read, so I wouldn't recommend it. But ultimately, when throwing the acid on the victim was left disfigured, completely paralyzed, in a state of physical and psychological pain. I believe completely blind as well. Completely in a state of physical and psychological pain. The acid attack was actually so damaging that, despite the fact that there were extensive surgeries and extensive medical treatments that had taken place on the victim to try and alleviate some of this pain and to try and alleviate the condition that he was in, he made the decision to go and travel to Belgium, where euthanasia is illegal, and took his own life. So legally killed himself as a result of the attack that had happened, or at least allegedly as a result of the attack that had happened. Now, the defendant's legal counsel argued, because ultimately the attack itself was a criminal offence, it would have been presumably GBH with intent, or even attempted murder, but then it was transformed into a new offence now, where she's now being charged with murder, because now the defendant had died as a result of her attack. Then we have this new instance where, okay, well, can the defendant in this case be charged with murder? Does the chain of causation exist? According to the legal counsel of the defendant, they argued that the doctor's injection, which legally euthanized the victim, had constituted a novus actus interveniens, which is just Latin for a new intervening cause of the death. and that the trial judge, when the trial judge withdrew the case of murder on the basis of this new intervening cause, the prosecution appealed, and the Court of Appeal would allow the case of murder to be tried. Ultimately, what was done is the issue of murder was given to the jury to determine whether or not causation can be found for the charge of murder, given that the decision to take his own life was one that was made by and influenced by the attack itself. So even if the defendant's legal counsel argued that, well, the injection itself is a new intervening cause, was the decision to take his own life one that was influenced by the attack? Obviously, the answer to this question is yes. In the previous lesson, what we did was explore the concept of causation when it came to the establishment of an actus reus for criminal law. This lesson, we're going to continue talking about this by examining the concept of causation in law, exploring the ways in which new intervening causes can contribute to the lessening of criminal sentence in some potential examples of case law. So like I've said, we introduced and examined a number of interesting factors which contribute to the issue of causation within the criminal law. Again, we are talking specifically about the actus reus of an offence, the act itself, the guilty act. This lesson is going to talk about some of these issues as well, continue to talk about it, focusing on this idea of new intervening causes and some basic principles which pertain to the causation of harm. And the idea is to essentially sum up some of the final issues that relate to causation within criminal law before we move on to looking at the mens rea of an offence, which is obviously the other side of the equation, the other element that is required for most offences in criminal law. So when we talk about causation, you will be met with, whether this is talking about causation within the context of the law of tort or within the context of the criminal law or even any other examples, but mainly those two are the main examples, you'll be faced with this particular Latin phrase, this idea of novus actus interveniens. What does this essentially mean? Well, the concept and the principle of novus actus interveniens recognizes that in factual circumstances in day-to-day life, when it comes to the various different legal matters that exist, whether it be tort or whether it be criminal law, there are a multitude of different complexities that pertain to these factual matters. There are multiple different causes which may contribute to the resulting harm. And so what we talk about there is this idea of new intervening causes, novus actus interveniens. Now, the general rule for whether or not the defendant's liability is a new cause or contributes to the components of compounding damage is that the defendant will be responsible for all of the natural and possible consequences of his or her act. So given that there are a number of different consequences that could arise, which may be natural or possible, then these are what the defendant may be responsible for. It might be easier to just highlight this in a number of different case examples. So from 1983, we have the case of Crown and Paget. In this case, it was a case which essentially examined whether certain acts can be considered to be novus actus interveniens, and the result of which absolved the defendant from liability. Specifically, this was a case of murder. The defendant had kidnapped his girlfriend and in a shootout with police officers had used her as a human shield. Now, the explanation of how this takes place is a very, very long explanation. The police officers had very poor visibility, for example, and a shootout would ensue, which ultimately leads to the girlfriend being shot by the police officers when they fired upon this defendant, believing it was the defendant and not just the defendant with a human shield. The Court of Appeal held that the shot of the officer did not constitute the novus actus interveniens, and therefore the defendant ought to be convicted. So it was not a new intervening cause, the shot from the police officer. And Lord Justice Goff stated that there can, we consider, be no doubt that a reasonable act performed for the purpose of self-preservation, benign of course in itself, an act caused by the accused's own act, does not operate as a novus actus interveniens. So what we see here is an example of a police officer being accused, or at least the defendant was accused of murder, but the police officer was accused of being this new intervening cause, the shot from the police officer. But it was dismissed on the basis that this could not constitute a new intervening cause, and therefore it could not absolve the defendant of liability in this case. In 2007, we see a similar case of Crown versus Kennedy. This case examined the nature of a Victims Act and whether or not the Victims Act can contribute to the cause of the result and therefore possibly absolve the liability from the defendant. Ultimately, what happens in this case is the defendant will supply the victim with some Class A drugs. This was done at the request of the victim, as it normally is. You don't often have drug dealers just giving victims drugs. The victim asked for some drugs. The defendant, being a drug dealer or being a supplier, had supplied the victim with some Class A drugs. The victim then self-injected, self-administered the drug themselves and would subsequently die as a result of this self-administration. The defendant was convicted of manslaughter, and on appeal it was held that the conviction may be overturned, owing to the fact that the victim had made their own voluntary and informed decision, and it was this voluntary and informed decision which represented a new intervening cause. Because if you think about it, the defendant can supply the victim with some Class A drugs, and the victim may decide not to inject them or self-inject them, or may inject a lesser amount such that would lead them to not die as a result. So it doesn't necessarily make sense to suggest that the defendant's supplying of the Class A drugs was the cause of the death of the particular victim, because but for that case, you could apply the but-for test, but you could also make the case that the victim's drugs, self-administration of the drugs, represented a new intervening cause. Okay. Lord Bingham stated that the criminal law generally assumes the existence of free will. The law recognizes certain exceptions, but generally speaking, informed adults of sound mind are treated as autonomous beings, able to make their own decisions how they will act, and none of the exceptions is relied on as possibly applicable in this case. Ultimately, they made the argument that the victim's actions represented their own free will, their own autonomous decision to self-administer the drug, to self-administer the dosage of the drug that they did, and subsequently die as a result of which. And all of this contributes to the idea that they are new intervening causes. Let's contrast this case then with the case that we looked at in the previous example, the case of Wallace from 2018, because you might think that there might be some similarities, even if they resulted in two different convictions. One was acquitted and one was convicted. So how do we reconcile these two things? Because ultimately, in the case of Kennedy, the victim made the decision to administer the drugs and therefore die, and the result of which was that this represented a new intervening cause. In the case of Wallace, the victim made the decision to go to Belgium to take their own life through euthanasia, but that did not represent a new intervening cause. It was not representative of that. Well, the decision to end the victim's own life in the case of Kennedy was a voluntary decision that had no influence by the defendant. However, in the case of Wallace, this decision to end the life of the victim, this self-confessed decision, was not seen as a voluntary decision, because it was a decision that was only brought to the fray. It was only made on the basis of the attack that the defendant had incurred onto the victim, the acid attack, which resulted in his decision to go and euthanize himself. And so as a result of which, this kind of free will, autonomous, voluntary decision element is what delineates the case of Kennedy and the case of Wallace. Let's just think about some of the other issues that relate to causation in a tiny bit more detail. One of these things is known as the thin skull rule. Generally, this is the rule that states that you have to take the victim as you find them. What this essentially suggests is that if the victim of an offence has some unusual condition, which may lead to them suffering a significant more harm as a result of the actions of the defendant cannot just avoid liability on the basis of that particular characteristic. So, for example, if there's an example that we see here from Herring, which is the idea of a defendant stabbing an individual who is a haemophiliac. Maybe it was the case that the stabbing of the individual, of the victim, would not have caused the victim to bleed to death if they weren't haemophiliac, if they didn't have haemophilia. And so the result is that you cannot argue that the condition that the victim had was a new intervening cause, or as a way to break the chain of causation for the defendant's actions. If you were, for example, to hit an individual in the face, but it turns out that that individual has some kind of blood clot in their brain, and the resulting attack to that person's head causes that individual to die as a result, you cannot argue that you are not responsible for that death because you hit that individual not assuming that they were going to die. You take the victim as you find them. So the condition of the victim does not break the chain of causation in that regard. Finally, then, let's talk about this 1975 case of Crown and Bly, or Blue. In this case, the defendant attacked a woman and had stabbed her. The victim was a woman and stabbed her. The attack had caused the victim to suffer a pierced lung. Now, when they went to the hospital, the victim actually refused to have a blood transfusion. Now, this blood transfusion would have saved her life. And the reason why she refused to have this blood transfusion was owing to her religious beliefs. She was a Jehovah's Witness. And for those of you who do not know, Jehovah's Witnesses do not believe in blood transfusions. There are lots of very controversial examples of cases where the parents of Jehovah's Witnesses have tried to refuse hospitals administering blood transfusions to their children, which may save their lives. Ultimately, a lot of controversial debate can be had about the religious liberty of an individual versus the life of either their children or themselves, whether or not a doctor would have to essentially respect the beliefs of this particular individual. Ultimately, the defendant was convicted of manslaughter because the victim ultimately would die, and they've appealed on the basis that he argued the refusal to receive a blood transfusion was not only unreasonable, but it also broke the chain of causation. Okay, because if it hadn't have been for the fact that she had a refused a blood transfusion, it would have saved her life. The blood transfusion would have prevented her from dying. And the defendant would only have been charged with ABH or GBH or some kind of other non-fatal offence because she would have been alive. So the idea of a charge for manslaughter is suggestive on the fact that it was the defendant that directly caused the attack, and the blood transfusion did not represent a new intervening cause, or shall I say, the refusal of the blood transfusion. Ultimately, the court argued that the refusal to have the blood transfusion did not constitute a break in the chain of causation, and so as a result of which the defendant was not entitled to claim the victim's refusal to get a treatment was a novus actus interveniens. Now, I'm not going to lie, this is a very controversial case, and the concept of the thin skull rule in this regard, and the taking the victim as you find them, is essentially applied here to religious beliefs. Whether or not religious beliefs are so fundamental to an individual's characteristics and an individual's life that they represent something like a condition, in the same sense that stabbing someone who had haemophilia represents an application of the thin skull rule. Some people argue that this does represent a new intervening cause, and that religious beliefs should not represent something that doesn't break the chain of causation. Some agree with the Court of Appeal and held on the argument that the defendant should have been charged with manslaughter, and so as a result of which there was no breaking in the chain of causation. This is a controversial case, so debate it in the comments if you wish.